Welcome back, everyone, to another live session with Franchising with FASA. Our discussion today is about franchising laws and tips for franchisors and franchisees. I'm Romany Thresher, and our guest today is Maria D'Amico from D'Amico Attorneys. Maria holds an LLB in law, obtained at WITS, and has been practicing as an attorney for 31 years in her own law firm, D'Amico Attorneys. Maria is an expert in commercial law and litigation and franchising. Maria also is also a qualified solicitor in the United Kingdom, completed her Canadian legal conversion exams as a civil and commercial mediator, having obtained her certificate from the ADR Alternative Dispute Resolution, the Alternative Dispute Resolution Group in London. Maria served as a legal advisor to the Businesswomen's Association and has been a FASA member for over 26 years. Maria has been involved with FASA for many years in evaluating franchise agreements to determine whether they are compliant with the Consumer Protection Act for new franchisors who wish to become franchise members of FASA, and is presently the chairman of the FASA Membership Committee. So hello and welcome, Maria.
Hello, thank you.
Excellent. So today I just want to remind everyone once again, you know how the algorithms work. Please share this, like this, share it with people who you feel may be interested in franchise opportunities, people who would like some more knowledge to understand how things work from a legal aspect. Share and like it with people you feel would like to know more. So as we get started, let's have a chat now about this about franchising and the legal side of franchising, which I absolutely know nothing about. So Maria, I'm so grateful to have you here today to talk to us about the disclosure documents and all sorts of topics surrounded by basically tips for franchisers and what to expect. So why should a franchisor use the services of a franchising attorney?
Thank you, Romany. Hi, everyone. A franchising law is quite a specialized area, and not all attorneys understand franchising. There are commercial attorneys who deal with contracts. Franchise agreement, in fact, is a contract, but it's the next level. It's specialized. Why is it specialized? Because we have an act that's called the Consumer Protection Act. And an attorney who deals in franchising would need to understand franchising law per se and intimately know the provisions of the Consumer Protection Act. So when they prepare a franchise agreement, it's got to conform with the Consumer Protection Act, the CPA. The CPA has regulations which actually sets out the information that needs to be inserted in a franchise agreement. So just to repeat, your franchise agreement has to be compliant in terms of the CPA, read together with the regulations. I'm of the opinion that if a franchise agreement is not CPA compliant, then the franchisee can resolve from the agreement. So what does this mean? The franchisee can actually get out of the agreement and not be bound by this legal document. We don't have any case law on this, so it's only a matter of time before we see how the judges and the court view it, but very, very important that your franchise agreement is compliant with the CPA.
Sure.
Also,
so it's quite an important document. It kind of is the document that gives the information, all the information about the franchise opportunity.
Yes, there is other documents as well, but your franchise agreement is your legal document that sets out the obligations of both parties, franchisor and franchisee, and also sets out all the monetary obligations. So a franchisee knows by reading your franchise agreement what monies they need to pay out from day one. So there's no hidden costs. That's the whole purpose of the CPA, is to do away with hidden costs. Also, from a franchisee point of view, very important that the franchisee takes their franchise agreement, also a disclosure document. The disclosure document provides all the information relating to the franchisor and their brand. So there's a lot of financial projections. So it's important that the franchisee takes their franchise agreement to a franchising attorney and gets them to check it out. Also advisable that the franchisee appoints an auditor who understands franchising as well to check out their disclosure document, check out their projections. Possibly any auditor that deals with retail would be able to assist on whether the projections are reasonable and realistic.
Wow, lots to consider. If anyone out there has any questions, or if you've got any comments and you would like to ask Maria a question about the disclosure documents or even the franchise agreement, please pop them and post them in the comment box. We will make sure it gets to Maria. So my next question to you is, explain the time periods required in the disclosure document and the cooling off period. And I've heard this term cooling off period for quite some time, and what's the cooling off period?
There's two documents. So let's start off with the disclosure document. This is what I mentioned just earlier, that contains a lot of information relative to the franchisor and their brand. So the disclosure document must be given to a franchisee, a prospective franchisee, at least 10 working days. So it's a disclosure document and the unsigned franchise agreement. A copy of the franchise agreement is given to your franchisee, your prospective franchisee. They've got 10 working days. What does 10 working days mean? It's a Monday to a Friday, and that's considered a working week. Or some people talk about 14 days. 14 days is normal days. So it can be any day, including a weekend and including a public holiday. So you've then got 10 days. So just an example, if today's the 1st of March, I, the franchisor, give you a prospective franchisee the disclosure document. Tomorrow, which is the 2nd of March, is when you start running your 14 days. Then the disclosure document can be signed after the 14th day. So if you as a franchisor are uncertain of the days, rather wait 1 or 2 days extra than before. Once again, it's got to be compliant with the CPA. I'm also of the opinion that if it doesn't comply with the CPA, the franchisee, even if he or she signs the agreement, may be able to get out. There is no case law on this. This is just, my views, and we will see how the courts view it in due course. Then you have the franchise agreement. So now, assuming your 14 days have come and gone, then your franchise agreement signs the franchise agreement. Your franchisee signs the franchise agreement. You now have another 10 days, working days, or 14 days as a cooling off period. So cooling off period is a legal term. That means your franchisee has, after he or she has signed, they've got 14 days to possibly get in writing. And if the franchisee has paid any monies to the franchisor, like an upfront fee, they will get the money back 100%. The franchisor may not retain a cent of that money. So there's your cooling off period. You basically have 10 days disclosure document, 10 working days, and then 10 working days in terms of your cooling off period. Now, a tip for franchisors is when your franchisee has signed the franchise agreement, please do not give them any training. Don't impart any of your intellectual property. Do not give them a copy of the ops manual, because on day 9, on day 10 working days, they then cancel the agreement. Then you as a franchisor cannot rely on any of those clauses in the franchise agreement, particularly a restraint of trade, to to make sure that your franchisee, who's now become your ex-franchisee, doesn't operate. There are common law assistance, but you don't want to rely on that. So do not give your franchisee any of your intellectual property until the cooling off period has finished.
That makes sense. That makes a lot of sense because, I mean, it sounds to me like you've got this disclosure document, so they're going to read the disclosure document. There's going to be a lot of time for them to decide whether this is the right choice for a franchisee to sign up. And pretty much it sounds like if they decide to opt out, no matter what, they can opt out. Okay.
Within the 14 days. If they opt out on day 15 or 16, then it's too late.
Then it's too late. Okay, so if it's after 15 days, then they are bound to follow through with their action.
Exactly.
Okay. And what can a franchisor do to minimize a franchisee's breaches? I mean, you mentioned the training, you mentioned because you don't want to go there. You don't want to be giving away all your IP and all your information before the 14 days. Are there any other tips?
I think it's important for the franchisor to have open communication and regular communication with their franchisee, especially in the beginning when the franchisee is not quite sure of the system. Sure, they may have done the upfront or the initial training, but you as a franchisor should have if not an open door, but certainly an open policy in terms of communication. There needs to be guidance. You should send out field advisors to go and do operational audits on the business and then give them guidance on where they are not conforming with your business system. Also important for your franchisee to know what his or her obligations are. Now, all those obligations are in the franchise agreement, but certainly does no harm to reinforce that in terms of your initial or upfront training and also ongoing training. The ongoing training is also very important. When the franchisor introduces a new product or new system or enhances their business system, there needs to be proper training so that the franchisees are able to take that product, take that service, whatever the business system entails, and move forward with it.
That's good advice. That's good advice because often people do stuff and they make things happen and they forgot to tell the rest of everybody else what's going on. And everyone's like, oh, yes. This has changed. And, you know, that can upset a lot of people because we have different type of people. Some people are very flexible in their ways, but there's other people that are more disciplined, or that's not really the right word, more rigid, you know, so they want that order, that sense of direction, that sense of knowing that you're not just upping and changing and doing stuff and then I must find out 3 months down the line from a fellow franchisee, oh, I didn't know that, you know. So yes, I feel that's really, really quite important. Any last thing you want to add? And then we're going to be talking about FASA and how you've been a member for 26 years at FASA.
I think from a franchisor's point of view, they need to evaluate their franchisee. Some franchisors are under pressure to bring in the money or have budgets to meet. What they don't understand is it's more important to get the right franchisee, the right caliber, the franchisee that suits your business system, your product, your service, whatever your business system as a franchisor is. So spend time evaluating your franchisee. If necessary, have them evaluated through psychometric testing so that you've got the right caliber. Very, very important because your franchisee contributes towards your brand. If your franchisee does something wrong, it affects your whole brand per se.
I like that. I think I agree with you. A lot of people are just wanting to sign people up for the sake of signing people up without checking whether that person fits in with the culture, whether that person fits in with the personality of the brand. And this is what's great about having interviews like these, because this gives people a feeling of who you actually dealing with. And so you don't waste time. I'm very open with sharing information because I want people to get a feel and a sense of who I am and what I'm about. And then you can decide whether you want to work with me or make contact with me. And the same applies to people in the franchise sector.
Well, I see that we've lost Romany, and I see that I'm live. So I'm not sure if there's any questions. I'm not on a Zoom, so I can't see if there are any questions. But I think we should just wait a minute and let's see if Romany hops back on. But I hope that that has been useful. A further thing while we're waiting for Romany to connect is it's very important for the franchisor to provide the correct information to their prospective franchisees. Because whilst the franchise agreement contains all the terms and conditions pertinent to their contract, if a franchisor has provided any projections, warranties, guarantees, any representations to the franchisee, and that is not part of the franchise agreement, then our law, the CPA, the Consumer Protection Act, is a section that states all those representations, warranties, guarantees, projections will then be included as if it was recorded in the franchise agreement. So that's very important. I see that Romany is not popping on. Another tidbit is the relationship evolves between the franchisor and the franchisee. So right in the beginning, it's like a new relationship, and it's more like a parent and a child, where the franchisor provides input, training, communication, guidance, and the franchisee may be like a child. That's probably in year 1 or 2. Then the relationship evolves, and the franchisee becomes more certain of the business system and could then become possibly a petulant teenager in year 2 to year 3, possibly in year 4, where they question the system. They question whether they need their franchisor or not. And then their relationship seems to evolve into, hi, Romany, I've just been talking here. Continuing, I was waiting for you to pop up. So let me just finish off. So in the final relationship, then it becomes more like an adult relationship. And that's probably by year 4, year 5, where the franchisor needs the franchisee and the franchisee actually appreciates the franchisor. So, yes.
Excellent. Thanks for popping. We had a power trip for some reason. So I do apologize to the audience. Thank you for carrying on there. Perfect, perfect. We've had some questions come in. I don't know if you've been reading any of the questions.
No, I haven't. Sorry.
Okay, no. That's fine. That's perfect, because then I know where to pick up. So we've had a question. I'm not sure in which context Derek DeToy is asking it in, but he says, just to make money and not look at the long-term building of the brand and to the future advantage of their stakeholders. So I'm trying to think, Derek, where that context falls in. Sean Goldsmith is saying, hi, Maria, good to see you. And then Dani Minthwana is saying, I almost signed up for a franchisor, but realized very quickly that he's all about meeting financial budgets and not necessarily about the business relationship. I sent him a list of questions and he never came back to me, as he didn't want to be upfront with some crucial details about his business. So yes, that is good insight on your part, Danny, because you must, you're going into a very long-term relationship with someone. So you need to obviously feel comfortable with the person, that you're able to ask them questions and they're going to be open with you about answering those questions. And if they're not willing to do that in upfront, then what's the point? Oh, Derek is saying franchisors must not be greedy and all about the money. That's what I meant. Very short-sighted. Absolutely agree. Maria?
Yes, hi. Can you hear me?
Yes.
Just also a further thing, another tip for franchisors is that their documents need to be consistent. We have terminology like an upfront fee, or some people use the word franchise fee, or some people use the word initial fee. There's no right or wrong. Doesn't matter what terminology you use as a franchisor, but it's very important that that terminology is used consistently through all your agreements. So, for example, in your disclosure document, if you use upfront fee, make sure that when you prepare your franchise agreement, you're using upfront fee. When you deal with the operations manual, you deal with upfront fee. Another example is marketing and advertising. So you can use it interchangeably, but with your documents, make sure one terminology, advertising or marketing, and then throughout. So you don't create confusion as to what is an upfront fee. Is it the same as the initial fee? How different? So yes, just remember consistency and simplicity. In fact, one of the benefits of the Consumer Protection Act is that all agreements must be simple and easy to understand. And in fact, that's a philosophy that I have adhered to since day one in my career. I have attempted to make my agreements easy to read. You don't have to have a doctorate in English to understand my agreements. And then when it comes to
yeah, that's so nice to hear, because I tell you what, you read some of these words, oh gosh, I need a dictionary. And that's what I think I like about the South African law when they change that. So it makes it easy to understand, because sometimes when I read things from overseas, there's big words that they're using, and it's very structured in a way that one just really doesn't know what they're talking about. So yeah.
And once you're used to the South African way, when you compare it to the UK, and Sean, close your ears here, and in America, their agreements are quite difficult to read. They have these long sentences, no full stops. Sorry, I'm not here to slate anybody, but South African agreements are really, people don't appreciate these. Well, I'm obviously talking general. There are some people that like to use a Latin phrase and that, but generally our agreements, certainly my agreements, are very easy to read compared to the legal documents overseas.
And that brings me to something else, which is one of the very big benefits of being a member of FASA, because we check that the people, the guys at the back at FASA, when you become a member, checks all the documents, make sure that they are compliant, make sure that everything is in place. So you actually protecting yourself as a franchisor, and you protecting your franchisee, which is somebody that they would feel appreciated. And something that I've heard franchisors, especially when they're expanding their businesses, is that they've said that the application process for them has been so much easier because of our the length as to what we have in South Africa, and the lengths we take to making sure that everything is dotted, everything is T'd, and everything is in place for everyone's benefit and everyone's protection. So that's something that I've noticed come out as well.
Yes,
what are
certainly.
So as a member of FASA, what has been the benefit of being a member of FASA?
It's the network, being part of the franchising industry. As franchising law is one of my core businesses, it's been in the forefront. So when when the CPA, the Consumer Protection Act, was being enacted, it took a couple of years, and there were various drafts before it became a final draft. There were discussions about it. So we, as members, part of the FASA community, were aware of what was happening. There's also now, there's mediation. So franchisor or franchisee could use the services of the mediator at FASA. And there's also a webinar, things like this webinar. You as a franchisor or franchisee, look at the subject matter. If it's of interest, you acquire this information. It's all part of that. And as you've correctly said, for you as a franchisor to become a member of FASA, they check to see whether your disclosure document and your franchise agreement is compliant with the CPA. That's an absolute big one. I know there's a small fee for it, but it's a small fee compared to going to pay in an outsourced attorney to check that the agreement is compliant.
And I also think it's a small price to pay to give your franchisee that reassurance, because I must say, I would definitely, if I was investing in a franchise business, be doing my due diligence. I'd be doing a lot of research, and I'd want to know that I have that peace of mind that I'm actually protected by a bigger body, that should something go wrong. Because you might think, oh, this is a great relationship and we're going to get on well, but then 3 years down the line, something goes wrong. It could go wrong, it may not go wrong, but at least it gives you and your franchise, both of you, that peace of mind that you have somebody there that should something go wrong, there's a place to turn to. So for me, that would be, especially as a franchisee, a big plus in deciding whether I'm going to invest in your business or not.
Yes, certainly.
So Sean is saying that he says, hi Derek, I agree at the extent a franchisor needs to balance both, because as a franchisee, the last thing you want is a franchisor that cannot afford to support you properly. That's very good, valid point. And then Sean is saying that he's found the UK documents to be easy to understand. He would love to compare. And in closing, we run out of time. Thank you everybody for watching. Thank you for your comments. And yes, share this with anyone you feel might find this useful to them. And would you like to get hold of Maria D'Amico, we will pop a link to be able to message her in the comment box below. So whatever it is you're doing, everybody, have a wonderful week further. And I just want to remind you that on Friday, we're hosting a virtual networking event from 9 to 12. We're going to be talking about the Poppy Act. We're also going to be talking about more brand visibility, as well as finishing off the working from home scenario. Are you prepared as an employer, as an employee? So come and join us if you'd like to participate or attend that event on Friday. So that's it. Thank you, everybody.
Thank
And
you.
yes, have a super week further, whatever it is you're doing.
Thank you, everyone.
And I have. Oh, sorry.